A landmark digital privacy case that has captured international attention. A Canadian civil tribunal has imposed a significant financial penalty on Elon Musk's social media platform, X, formerly known as Twitter. The case, which has been unfolding over several months, centers around the platform's refusal to comply with an order to remove a non-consensual intimate image. Highlighting the complex intersection of digital rights, privacy protection, and international jurisdiction in the modern internet age, the British Columbia Civil Resolution Tribunal, a specialized legal body designed to handle civil disputes in Canada's westernmost province, made its initial ruling in March of this year. In that decision, the tribunal determined that the posting of a particular intimate photograph of a woman, who has been referred to pseudonymously as TR, to protect her privacy, constituted a clear violation of British Columbia's Intimate Images Protection Act. This provincial legislation, designed to combat the growing problem of non-consensual sharing of intimate content, provides victims with legal recourse when their private images are distributed without permission. The Intimate Images Protection Act represents British Columbia's comprehensive approach to addressing what is commonly known as revenge porn or image-based sexual abuse. Under this legislation, sharing someone else's intimate images, or even threatening to share them without their explicit consent, is considered a criminal offense. The law recognizes that such violations can cause profound psychological harm, damage to reputation, and long-lasting trauma for victims, particularly in an era where digital content can spread rapidly across global networks. Following the March ruling, the social media giant was expected to comply promptly with the tribunal's order to remove the offending content. However, according to the tribunal's subsequent findings, SS Corporation failed to take the necessary steps to fully eliminate the intimate image from its platform. This defiance of a legal order prompted the tribunal to take further action, demonstrating the serious consequences that can result when major technology companies refuse to comply with local privacy protection laws. In response to X's continued non-compliance, the tribunal imposed a fine of 100,000 Canadian dollars, which amounts to approximately 72,307 United States dollars. This penalty represents the statutory maximum allowable under British Columbia's Intimate Images legislation, sending a clear message about the province's commitment to protecting victims of non-consensual image sharing, regardless of the size or influence of the platform involved. The tribunal's decision went beyond simply imposing the initial fine. However, recognizing that X might continue to ignore the removal order, the tribunal invited the woman to request additional penalties of up to 5,000 Canadian dollars per day in the event that X continues to not comply with the March order. This escalating penalty structure creates ongoing financial pressure on the social media company and provides the victim with a mechanism to seek continued redress for each day her intimate image remains accessible on the platform. During the legal proceedings, S Corporation mounted a jurisdictional challenge, arguing that a Canadian provincial tribunal lacked the authority to regulate content on a global social media platform. According to the tribunal's ruling, the company argued the tribunal lacked the authority to make X restrict or eliminate the online availability of intimate images outside British Columbia. This argument reflects a common defense strategy employed by international technology companies when facing local content regulation, essentially claiming that provincial or national laws cannot extend beyond geographical borders in cyberspace. However, tribunal member Eric Regier firmly rejected this jurisdictional argument in his comprehensive ruling. Regier dismissed that argument, noting X's position would call into question whether British Columbia residents could receive any meaningful protection under the province's Intimate Images legislation. The tribunal's position establishes an important precedent, suggesting that local privacy protection laws can indeed have extraterritorial effect when they are designed to protect local residents from harm, even when that harm originates from international platforms. This case represents more than just a financial penalty for a major technology company. It symbolizes a growing global tension between the borderless nature of the internet and the sovereign right of nations and provinces to protect their citizens from digital harm. The ruling suggests that social media platforms cannot simply ignore local laws by claiming their global nature exempts them from regional jurisdiction, particularly when those laws are designed to protect vulnerable individuals from specific types of harm. The implications of this decision extend far beyond the immediate parties involved. Non-consensual intimate image sharing has become an increasingly prevalent form of digital abuse, with victims often finding themselves powerless against the viral nature of online content distribution. The psychological impact on victims can be devastating, including anxiety, depression, social isolation, and in some cases, suicidal ideation. Legal experts consider this case a significant step forward in establishing meaningful accountability for platforms that host such harmful content. For the woman at the center of this case, identified only as TR, the tribunal's strong stance represents validation of her right to privacy and dignity in the digital realm. While the tribunal declined to order additional compensation for the time she spent pursuing this legal action, the substantial fine and the potential for ongoing daily penalties represent a meaningful acknowledgement of the harm she experienced and the platform's ongoing responsibility to address it. The broader tech industry is likely watching this case closely, as it may signal a shift toward more aggressive enforcement of local privacy protection laws against international platforms. Companies operating global social media services may need to reconsider their content moderation policies and compliance procedures when faced with local legal orders, particularly in jurisdictions with strong privacy protection frameworks like Canada. As this case moves forward, the question of whether X will ultimately comply with the tribunal's order or continue to face mounting financial penalties remains to be seen. Some legal experts suggest the fine will likely go unpaid, raising questions about the enforceability of such decisions against international technology companies. However, the precedent set by this ruling may encourage other jurisdictions to pursue similar actions, potentially creating a web of legal obligations that could compel compliance through cumulative pressure. The case also highlights the evolving landscape of digital rights and platform accountability in an era where technology companies wield unprecedented influence over information flow and personal privacy. As governments worldwide grapple with how to regulate global digital platforms while protecting their citizens' rights, this British Columbia Tribunal's decision may well become a reference point for future legal actions involving non-consensual, intimate image sharing and platform accountability. This landmark ruling represents a significant moment in the ongoing dialogue between digital platform operators and the legal systems that seek to protect individuals from online harm, setting the stage for continued legal evolution in our increasingly connected world. As we continue to navigate this complex digital landscape, where technology giants and government regulations intersect, cases like this remind us of the importance of staying informed about the policies that shape our online experiences. The outcome of this British Columbia Tribunal decision could very well influence how social media platforms handle privacy violations and legal compliance across the globe, making it a story worth following as it develops further. If you found this deep dive into digital privacy rights and platform accountability valuable, please consider supporting West is Best by hitting that subscribe button and giving this video a thumbs up. Your engagement helps us continue bringing you comprehensive coverage of the most important tech policy stories from around the world. Until next time, stay informed, stay engaged, and remember that in the digital age, knowledge truly is power.